Hello and welcome to today's session for MBL Seminars, an introduction to the Landlord and Tenant Act 1954, Part 2. My name is Sarah Thompson-Copsey. In today's session we'll be looking at the 1954 Act, or rather Part 2 of the 1954 Act, and looking very much from an introductory level, so we'll be dealing with an overview of the Act, how the Act works and how it sticks together. Tenants who occupy premises under a tenancy, generally speaking, for business purposes, have security of tenure when that tenancy ends. And that means that when the lease ends, when the contractual term of the lease comes to an end, generally the tenants can stay on in occupation of the premises on what's called a statutory tenancy, a statutory basis. And that statutory basis is generally, by and large, the same terms and conditions as the old expired tenancy. The 54 Act, the Landlord and Tenant Act 1954, prescribes the steps necessary to bring such a statutory tenancy to an end, steps to be taken either by the landlord or by the tenant. And the tenant is, where the landlord takes those steps, entitled to a new tenancy on the landlord having brought the tenancy to an end within the prescribed provisions of the 54 Act. And that new tenancy, not the statutory continuation, but the brand new tenancy it's entitled to, is roughly on the same terms and conditions as the old expired contractual tenancy, but at a market rent. And that tenant is entitled to that tenancy unless the landlord can prove one of 7 statutory grounds of opposition. 4 of those grounds are discretionary, as we'll see. 3 of those grounds are mandatory, and 3 of those grounds, but not exactly the same as the mandatory ones, are also compensatory. In other words, if the landlord shows that ground of opposition, proves that ground of opposition, and sometimes even if he only puts that ground of opposition down on paper, the tenant is entitled to statutory compensation. So we're going to be looking at the Act very much, as I say, from a sort of overview point of view. Nothing is going to be in depth, but I hope you'll come away at the end of today's session with an idea of how the Act works, when it works, and what the problem areas are in relation to this Act, or at least some of the major problem areas. So we won't be dealing with everything to do with the Act, and we won't be dealing with anything in particular detail, but I hope it will give you a shape for the Act and a way of looking at these types of tenancies, being able to recognise them and recognise the problem areas in order for you to go away and then do more research if what we look at today doesn't actually resolve the problem for you. So as you can see from the first overview slide there, we're looking at security of tenure for business tenancies. This gives them a statutory continuation of their lease, their old expired lease, once the expired lease has come to an end. The lease termination methods, the ways in which the lease can be brought to an end, the contractual tenancy can be brought to an end, are to some extent restricted under the 54 Act. Not everything is restricted, but an awful lot of things are restricted. It gives the 54 Act, the tenant, an entitlement to a new lease, and that lease will either be by agreement or by order of the court. And if there is no new lease that's granted because the landlord has opposed on one of certain statutory grounds of opposition, then there is the possibility of statutory compensation being payable to the tenant by the landlord. So let's look then at when security actually arises. This is the next slide that we're looking at. Section 23 of the Landlord and Tenant Act 1954 provides when that security of tenure arises, when this ability to remain in occupation and get a new lease actually arises. The tenant must have a tenancy. We'll look at all of these in more detail in a moment. The tenant must occupy the premises, and he must occupy them for business purposes. And it can be an individual, or it can be a company or a partnership. And it must be a non-contracted out tenancy. Now, I've called it a contracted out tenancy. Often it's called an excluded tenancy. But what do I mean by a contracted out tenancy? Well, what I mean here, as we look at the next slide, is a tenancy that is actually contracted out of the security of tenure provisions under the 1954 Act by using the prescribed method of contracting out security of tenure. So the Act still provides that it applies to a tenancy, but it simply doesn't give the tenant, on the ending of the tenancy, the right to any statutory continuation. So when the lease comes to an end, the tenant must vacate the premises or it remains in occupation as a trespasser. So recognising a contracted out tenancy should be fairly straightforward. First of all, it will only apply where you've got a fixed term tenancy. So where the tenant's moved into occupation and is simply paying rent, and you've therefore got some kind of oral periodic tenancy, you haven't got a contracted out tenancy, partly because it's not fixed term and partly because there's no agreement that you can actually attach the contracting out provisions to. So you need to have a fixed term tenancy. The tenant must have received a prescribed warning notice served by the landlord before the tenancy is entered into, and this tells the tenant that he's about to enter into a lease or an agreement for lease that will be contracted out of the security of tenure provisions of the 54 Act. And that's important. It's important that tenants know what they're doing and take legal advice on it. So there's a big warning notice there across this notice, which generally is a warning notice, advising the tenant of the fact that it actually is giving up rights. And that may be important to the tenant. It may be expecting to stay on, but it may also be paying rent on a different basis, on the basis that it's actually expecting to stay. And it may therefore pay a different amount of rent if it knows it has no security of tenure. Now, for the whole procedure to be correct and for the tenancy to actually be contracted out of the 54 Act, the tenant then has to have sworn a declaration, either a simple declaration, if there's enough time between serving the warning notice and entering into the lease or the agreement for lease, at least 14 days, more than 14 days. If there's less than that 14-day time period, then there needs to be a statutory declaration by the tenant. The tenant doesn't have to produce a copy of this to the landlord, but the landlord will want to see it. So if you're acting for a landlord in these particular circumstances, you're going to want to see both the copy of the warning notice that you yourself will have served, but also a copy of the tenant's declaration. And both of these are actually endorsed on the tenancy agreement in any event, but you still want to actually see them. But the actual entering into them is endorsed on the tenancy document, even if it's not attached to the back of the tenancy document. So that's how you actually recognise a contracted out tenancy. If it doesn't comply with all of that, then the tenancy is prima facie within the 54 Act. So we're going to look now in more detail at how the security actually arises, the meaning of tenancy, occupation and business, which give rise to security of tenure. We'll then be looking at ending the lease and the effect of different methods of ending the lease. We'll be looking at the forms of notices that can be served and how they're served. And we'll be looking briefly at the different grounds of opposition and the problems that those individual grounds of opposition can give rise to, concentrating on two of the most popular and common grounds of opposition: the landlord's wish to redevelop the premises or the landlord's wish to occupy the premises for his own purposes. And then we'll be looking at the